everybody. Thank you for joining us today. Today, I'm very pleased and happy to talk with Professor Tania Sordin about artificial intelligence and justice. Thank you, Professor Tania Sordin, for being with us today. You're not only a professor at the Newcastle Law School, but also the dean and the head of the school. I'm going to leave you the floor to present maybe your work and your research interest if you want to give us some word of it.
Thank you, Karima, and bonjour, bon matin, and bonsoir to everyone. I will be presenting in English today, but first of all, I want to acknowledge the traditional owners on the lands upon which all of us meet and pay my respects to elders, past, present, and emerging. So I'm delighted to be here today and to talk about some of my work, which is really focused on technology and justice as well as AI and justice. And I think one of my former collaborators, who I still work with from time to time, Professor John Zalesnikov, is joining us also from Australia. And I start by mentioning John because some of the early work that John and I did in 2003 and 2007 was actually building AI systems in legal domains. And since that time, a lot of my research work and my evaluation work has been focused on technology more broadly. So in the last year and a half, I've done quite a lot of work on justice apps and evaluating justice apps. And we'll have a book coming out next week on the topic. And my other work and another significant strand of my research work is focused on judges and artificial intelligence. So I'm delighted to be here and to talk about some of my work and some of, I think, the thinking in this area about where the justice system might move towards in the future. And so I think I perhaps might hand over to Karima, because I think the approach that we were using today was that she was really going to ask me a number of questions and then I would respond. So delighted to be
here. Exactly. So just a quick information. At the Cyber Justice Laboratory, we are a research center, and right now we are leading a project called Autonomy Through Cyber Justice Technology. So this discussion is actually at the core of our research project. So it's going to be very interesting for me and for our audience to hear this discussion with you. Actually, I just want to make an information that she's in Australia right now. It's in the morning, the day after. So good morning for the Australian audience with us today. And yes, I'm going to ask you some questions and we can do the discussion this way. First, could you give quickly our Canadian audience an idea of the impact of technology in the Australian justice system?
My intention is to briefly share a screen. I won't be using much PowerPoint, but from time to time, I have some material that may be of interest to the audience. And so I'll just quickly share my screen so that I can perhaps describe those developments in Australia and elsewhere. And in terms of some of the developments that I think are relevant, I tend to divide up technological change in three ways when I'm talking about it, both domestically and internationally. And it's not precise in that clearly there are technological developments that are both, if you like, supportive, replacement and disruptive. But I think it's a very useful way to understand ethical approaches and also justice redesign issues to divide it up somewhat. And most of the developments within Australia have been in the supportive and replacement technology areas. But over the last year, we've seen, I think, some growth in the disruptive area. And in some jurisdictions, there is far more growth than in others in terms of disruptive technologies. So I've written quite a bit on the smart court system in China and the capacity now to deal with a matter from beginning to end through a WeChat function, and the judge AI systems in China, for example, that include nudging and correcting judges, which raises some ethical issues as well as independence issues internationally. But dividing it up in this way is helpful, I think, because many of the developments, and particularly over the COVID era, is we've seen a lot of growth in terms of the supportive technologies. And they're often the technologies that help inform and advise people about what they could do at a very simple level. But they include the video hearings, the simple apps, the information that can come up, and perhaps even forms that can be completed online and then either sent in. More evolved technologies include the replacement technologies, where you have automatic letters, automatic listing, you have some capacity for automatic triage. And of course, we've seen a significant growth in this area with apps. And justice apps, I think, are very interesting. When we look at the number of apps around the world and we look at how people are using apps to access information about health or travel or indeed anything else, you can see that the potential in the justice system is enormous. So most of the reforms in Australia have taken place in these first two areas so far. We have had some growth in the disruptive technology space, and often disruptive technology is linked to artificial intelligence. And there we've had apps that are now much more predictive than at any point in the past. And in addition to the predictive AI, we also have some technologies that are built onto family dispute resolution apps that, for example, can determine what financial contributions a couple have made, and determine budgets and determine a whole lot of things through the use of AI. So it's not just AI replacing or replicating judicial decision making, but it's actually AI having some other offshoot functions, which I think is quite interesting for lawyers in terms of their use into the future. So I think that, again, in common with many jurisdictions around the world, many of the developments are in these first two areas over the next 5 to 10 years. But beyond the next 5 to 10 years, we're seeing the disruptive technology developments. And in some jurisdictions, that's already happening. And I think China is a very good example.
True. So you kind of already answer a bit of this question. What could be the use of AI for the justice system? And do you have any current example of AI tools implemented in the justice system that works?
Sure, and one which I'll refer you to, I evaluated a family law app this year and completed that, which I discuss in some of my work. And it's a very interesting system. It's called the Adu system, and it has some offshoots that come from that, with a robot, if you like, that helps in terms of populating documents in the background. But the AI piece that I thought was very interesting was a piece where the couples provide consent to, if you like, the AI to enable all bank records over the past 5 years to be considered by that form of AI. And that form of AI then tracks contributions and is able to come up with budgets for the future for a family that is separated into two households. This is quite interesting, because when I talked with lawyers about what they thought about this app, those that had used this part of the app, they said, well, look, this saves us, sometimes months and months of time, because the alternative was for lawyers to be sending bank records between one another, acquiring additional bank records. And also the lawyers don't necessarily have the skills to be able to create the financial spreadsheets and to create the material that really the AI system was able to do within 15 minutes. And I give that example because I think oftentimes people consider that AI is really only responsible for replacing human decision-making. But this is a very interesting example about how a form of AI can support lawyers and support couples who are going through the divorce process. That again, that app and some of the other ones are interesting because they have a lot of triage functions attached to them. So I actually had a pretend divorce last year and used the app to see what it was like as part of my evaluation. We also interviewed a number of people who had used the app, and what it does is, as I said, you go in, you start to talk to a robot Lumi that populates material, and it does have voice to text and text to voice capacity, although I think most people will use it on their phone as a straight text capacity. And then you're triaged into different referral streams depending on what your needs and your background are. And so you'll get an email, for example, in the morning asking, how are you going, and do you need support, and do you need to talk with a tax advisor or a financial advisor? And this triage approach, which can triage you in to see a lawyer and in to see a mediator, I thought was very helpful and quite supportive. Now, of course, an app like that isn't for everyone. And it's surprising, though, to me that a number of people who had used the app had been in a relationship for more than 20 years. I did think that the only ones who would use an app like that would be young people, but that wasn't actually borne out by the statistics in terms of the use of that app. So again, this is, I think, an example of justice apps that sit in the background of the justice system and can help people resolve their disputes by creating a platform and a different way of exchanging information. And the divorce question is called Adieu. So you can look it up online, and you can go in and even play with it and have a look at it. There is another one in Australia called Amicus, which is one where they have skimmed information from court files about potential outcomes. And fortunately, they went beyond that to also look at lawyer files through our legal aid system. Again, it gives an indicative range of outcomes which might be helpful for couples who are attempting to negotiate a financial settlement. Again, these are, I think, really interesting developments that often aren't considered. And the future of apps, I think, is really quite extensive in the justice sector.
There's a question from the audience asking if you can share insight on the effect of AI on dispute resolution system.
Yeah, I think that's quite a big question, because I, aside from having a background as a lawyer and having a background as a tribunal member, as an adjudicator, I also work as a mediator and have worked as a conciliator. And I have a lot of passion for mediation and conciliation and can see the many advantages. And one concern that I have is that governments in particular may consider that forms of AI that give you an indicative range of outcomes and are able to predict, for example, what the outcome might be should you progress to court, might be seen as resolving or able to resolve all disputes that are presented. And that's certainly not the case. Where there is a continuing relationship, there is a real need for communication to be established between the parties, even if it's via Zoom, as it is in a COVID-19 era. So I think that AI is not a panacea, and it's not something which is for everyone, but it is something which can act as an important adjunct. It can certainly sit in the background of mediation. And for some couples who are negotiating with one another directly, and many do, and I'm not just talking about family law, but also if we look at people more generally, then this can be a really important tool in terms of promoting and supporting settlement. I did see that there was another question that came up, I think, as we were talking.
It's a legal question. What happens if one spouse say yes to the app and the other no?
I think that at the moment, if one says no, then it doesn't proceed through that system. There are advantages, though, and it may well be that the family lawyers, for example, just decide to use that one AI offshoot, and our clients may consent to that. So they may consent, for example, to their financial records being dealt with in a way where there are considerable cost and time savings. However, they may not consent to something else, an extension. But on the Adieu system, what you do is you use your phone and you invite your partner through the ADU system, do you want to do it this way? And yes, for some couples this will work. It's not for everyone, but it's something which is available. I think the building on to the tribunal and court system is a different question again, and the extent to which a court, for example, might say that a form of Judge AI or a form of AI is compulsory is a very interesting ethical question as well, and a question which is linked to triage, which I'm happy to talk about as well.
Okay. Based on your research, in your opinion, where AI tools in the justice system should be implemented and should not be implemented?
Well, it probably takes us to that question of triage. And so a lot of my work on Judge AI, and I'll distinguish that because in my view, the justice system is quite a vast system, and the court and judges are a small part of that, absolutely critical part of it, but a small part of the overarching justice system. So first, perhaps I'll confine my comments to the court system. And this really raises questions about triage, and I might just share my screen for a moment to talk about triage and see if I can. And so as part of some of my recent work, I've done some questions which can help in terms of should a Judge AI form be used. Now, it seems to me, most likely based on my research to date, that we will see Judge AI, that is the complete replacement of human judicial decision-making in many jurisdictions, being restricted to quite small matters, regulatory matters, contract matters. And we're unlikely to see it completely replacing decision-making in the family or the criminal context, where there's probably been a bit more research and more concerns raised. In addition to that, of course, it makes a significant difference if you have a system which is based on precedent, or you have a system, a common law system, or you have a system where sometimes there is limited discretion. So the different categories that I suppose I've thought about in the context of factors to consider about where you would use a system of Judge AI, initially has a form of AI already resulted in decision-making taking place. And that's relevant. For example, in Australia already, we have AI being used and has been used for now a number of years to determine motor vehicle property cases. And so this determines what amount of money should be paid to effect repairs of a motor vehicle. And there is a real question, I think, if you've had a form of AI that's made an initial decision, should then a human being consider what is almost an appeal from that decision, but maybe, of course, a first instance decision. And this is a very important matter to consider, because some forms of AI that are already involved in decision-making have been problematic. And so just the other day in Australia, we had a $1.2 billion settlement of a scheme which was called the Robo debt scheme. And the Robo debt scheme was introduced in the social security area, and it was a way of attempting to recover debts from people who it had thought had been overpaid. It was an automatic system without much human intervention, and thousands of people received letters from the government which basically said that they owed debts to the government in relation to social security. This had some terrible consequences, aside from pushing many people into severe depression and anxiety. And there's some evidence that people suicided as a result of receiving these letters. There was a government inquiry into this robo-debt scheme. And as I said the other day, a class action was settled for $1.2 billion, which is payment back to those who are involved. That scheme was really problematic because although there was some administrative review that could be done by humans of decisions in that scheme, and there is evidence that there were a number of decisions that were made that overturned what the robo-debt said, it's really questionable about whether or not that was an adequate review mechanism. And Had it been reviewed by an AI system, one wonders whether the same decision would have stood in the longer term as well. So I think that's a really key category. Vulnerability is another category that I think is relevant when we're thinking about this. Is the person vulnerable? Do they have technological literacy? Are they able to engage adequately? Do they have support? Do they have adequate bandwidth? I know that I was talking with somebody in India yesterday, and it's very difficult in some jurisdictions to have good bandwidth. It's something that in some countries we take a bit for granted, but in many places it's actually a significant issue. And then there are other factors also about whether or not a person can engage and actually advocate. Now, sometimes some of the apps and AI systems can help people advocate as well. However, sometimes problems and legal problems are multidimensional, and we may lose some of that important nuance that exists if in fact a human isn't engaged. A continuing relationship between the parties, I think I've inserted this partly because of my alternative dispute resolution background. However, there's a real question around whether or not something which is simply advisory or determinative is appropriate, where there's a continuing relationship, and where there are other opportunities that could emerge from a settlement discussion. The next one, is the human judge bound by a weak or strong discretionary arrangement? And sometimes some judges have more discretion than others. And if they've got more discretion, then arguably it's more difficult for Judge AI to then replace the judge. Are there high levels of complexity or novelty? That may again be something that rules something out of an AI system. Are there high levels of emotion? And I looked at and I saw the early iterations of the CRT intake questionnaires, which didn't make it, I think, into any of the later iterations. But I remember seeing one early on where they actually asked how people felt about the dispute. And it wasn't included in some of the later work, and I was interested about why that wasn't the case. But if there are high levels of disputant emotion, it may be that AI should not be used. However, on the other hand, you could say that at times a form of AI might be more useful to litigants who are dealing with somebody who is more excessive in terms of their emotions. And then I think that last question, which is really around whether or not people consent, or whether there's a distrust of a form of AI. And initially, I think we can expect it, particularly in relation to Judge AI, that there is likely to be a lack of trust. There's also likely to be an expectation that it will be perfect or very exact initially. And I think that reality is unfounded. It's not going to be like that. There will be mistakes made, and there will be mistakes made as a result of the data samples that are used. And it will not be a perfect system. And machine learning of itself is great because we can learn each time a decision is made. However, initially there will be some issues, I think, with comfort.
Good. Well, in the field of ODR, we've seen that technology actually has improved somehow the access to dispute resolution, and there is actually a good satisfaction from the users and the citizens who use that kind of platform, let's say in consumers dispute and stuff like that. Do you think that in that case, in ODR especially, AI could be an improvement to improve access of justice? And what do you think about it?
Yes, I do, and I don't know whether John Zalesnikov is online. He may well be. I'm not sure, but even years ago, he created a system called Family Winner, and it was interesting because what the form of AI did was it produced the range of outcomes that people could expect. So it's a lot like some of the current apps that we have, and we're seeing in the ODR space in Australia. And again, I think very interesting systems because they could highlight to a couple in a family dispute situation why they saw the dispute differently. And that, of course, can assist them in terms of settlement negotiations. I think without a doubt, there are lots of opportunities for AI use as part of ODR. It's just the question about where we draw the line and where the human is replaced, and making sure that the triage function is effective so that people can go back to a human being when they need a human being. And then, of course, there's these very interesting questions around how lawyers will be engaged in all of this as well, and the extent to which there will be unbundling of legal services. And of course, the arrangements around the world are very different about what lawyers can and can't give advice on, and the extent to which they can give advice on a single matter or a moment in time. And there are the regulatory sandbox programs that are underway now around the world to look at the unbundling of legal advice, and these will have an impact into the future. It's about lawyers perhaps seeing their role a bit differently in different types of disputes, because unbundled legal advice might be appropriate in relation to some disputes, but not others.
Talking about lawyers, many in the legal community are afraid of AI tools, justifying their fear by, they're afraid of being replaced by AI tools. So is it a reasonable fear?
I think a lot of the research really around the world shows that there's a vast amount of unmet legal need. So many people with legal problems can't afford to see a lawyer, never see a lawyer, and have huge difficulties. So many of these tools are really more directed at that group, and in a sense they will create some work for lawyers if they are prepared to be engaged in unbundled legal advice. So there are opportunities also, I think, for people to be put in touch with lawyers earlier, and for lawyers to have a different role perhaps from the role that they've played in the past. There's also a real tension there as well, and I suppose one of the concerns that I have, and again looking internationally, is that a lot of the big firms are very much involved in AI and sometimes have set up spin-off firms that are part of their, if you like, stable of activities. And the smaller firms are often really not able to compete with the innovation and I think expenditure that's useful to set up something which is more comprehensive. And this can create very much a two-tier system, so that you have much more sophisticated AI at the fingertips, if you like, of the big firms, and the small firms, I think, being disenfranchised or not being as engaged. So the impacts on lawyers, my conclusion is, would really be quite uneven depending on where they are and how they get involved. I think for those that get involved in the justice apps and the platforms, there's probably opportunities for more work. And for the big firms as well, they need to be able to use AI to be able to project manage and advise their clients with, useful data and analytics information. It's probably that middle tier that's disengaged, that where there will be job loss, or there's potential job loss for the future. Lawyers are very good though at reinventing themselves. So, I think there are other shifts where they're increasingly working in-house and working with government in different sorts of ways, which probably really wasn't imagined 20 years ago as well.
And what about judges?
Yeah, I think, again, there's big variation around the world. So Canada has, for example, quite a large number of judges compared to some jurisdictions per head of population. In Australia, it's quite low, and it's quite low, the number of judges in Australia, because we've had tribunals for a number of years, but we also have a number of mandatory ADR systems that operate that are intended to divert people away from the court system. But it would be very unusual, for example, for a judge in Australia to be dealing with a matter which only had a $5,000 claim. That sort of matter would tend to be diverted out either to a magistrate, a tribunal, or a ADR system. So the impacts on judges are going to be different according to the jurisdiction. It seems to me that it's inevitable that small cases, simpler cases, are less likely to go before a human judge, and that's the area where we'll see most judge AI emerging at least initially. And yes, there will be an impact on lower tier judges and lower tier tribunal makers. But we're some way away from that, I think, at least 10 years before those impacts start to be felt across the justice system. In somewhere like China, there is a real, I think, push to create a judge AI system. And aside from Estonia and a couple of other small international examples, that's, I think, where we'll see most change. But again, that's a system where there is what you would call weak discretion, in that the judges haven't necessarily had that much discretion to begin with. So judge AI, it's more likely to be successfully introduced into those jurisdictions.
Okay, good. Let's say that kind of tool reached the court, but in the legal field, there are many rooted practices and rituals, and it's hard to change and modernize the justice system. There is a deep resistance from practitioners, from judges and lawyers. How do you think the legal community would more easier welcome AI tools, and what should be done to promote the fluent integration of AI? Should we include them in the process of designing these tools, or what do you think?
It's a very good question again. So I thank you in advance for some of the difficult questions that you've prepared this morning here. And so the question is really about how do we integrate different voices into the development of the justice system of the future. And I think, from my perspective, it's really important that lawyers and judges are involved in the design of the justice system of the future. And I do have a fear that if things are really coming through from a government and executive perspective only, without including judges and lawyers, then what you will have is a system which could really potentially have a very negative impact on the independence of judges, the rule of law, and indeed the democratic system into the future. This resistance that you've talked about in terms of lawyers and judges, again, it's patchy. It's not all lawyers and it's not all judges. And there are some judicial commentators and some lawyers who are very supportive, I think, of AI developments. And there are a lot who really, I think, don't understand what this means and how the world might change over the next decade as a result of the growth in terms of machine learning. So I think it's wrong to assume that everybody is necessarily negative. I think that those who are out there are concerned about the ethical impacts and the impacts on the system in the longer term. And it's really appropriate that they are concerned and they need to be engaged in this conversation. The reality is, though, unless governments are prepared to invest in this area and in justice more generally, then it's likely that we will continue to have quite a creaking, antiquated system into the future. So there does need to be a level of investment. And that's a challenge as well. I think, though, looking back over the last year with the COVID-19 pandemic, most of us would never have imagined that so many court hearings and so many court events could be dealt with virtually or online. And that shift, I think, has created some discussion amongst both judges and lawyers about what might be possible or feasible. And certainly it's created a world where the digitisation of court records is much more possible, which in turn makes AI much more possible. So I think reviewing this, things have changed even over the last year because there is a greater acceptance of technology. That acceptance of AI will take a bit longer, but the reality is that judges and lawyers in their day-to-day world are using AI all the time without being aware of it when they make purchasing and other decisions. And it's a question of us growing more used to thinking about these things in the justice sector. But there will be pressure not just from government and the executive. There's pressure from the broader justice system and these justice apps, and each of those begin to exert pressure, I think, on courts and judges.
And to continue on that question, there is a question from the audience. The person said that should we not other communities than legal communities, like citizens, I guess, or social communities or marginalized association, groups of people that are involved in the process.
Absolutely. And I'm a big fan of human-centered design. I think the issues are that judges, for example, are not used to being engaged in human-centered design approaches, and we do need very different ways of looking into the future. I might, in relation to that question, just share another screen which is relevant and talks about ethical principles. And when we're, I think, redesigning for the future and redesigning a system for the future, we can't just think about it in the context of the impact on a court process. We need to think about societal, sectoral, institutional, group, interpersonal, individual impacts when we're thinking about ethics and the use of ethics both in individual cases but also more generally when we're redesigning for the future. And so I've drawn up this table really based on, I think, some of the work that's been done on medical ethics, which enables us to consider, I think, ethical issues in a different way and in a more holistic way, so that we're really thinking, well, how are the humans that are engaged in the justice system impacted by these changes? To what extent do we have a litigant voice, which enables us to determine how effective something is? And it comes back also to what I think is really interesting, and that is that ease of use when you're looking at medical apps, and I look at that in the context of justice apps, is really the primary criteria or the initial criteria that you look at in terms of app effectiveness. Yet ease of use is not actually something that we've considered all that much in the justice system. And often when we change rules in the justice system, it will be a team of judges with some lawyers who come together and they'll work out something and they will craft something which is based on what the previous rules look like rather than something that might be understood by a litigant. So we really have to shift and reshape the way that we design things. And I think that's one of the reasons why you've got a response in Canada to set up a whole new tribunal rather than to necessarily look at reforming an existing system, because sometimes it's easier to set up something which is new. I've got a problem with that because I think that there's a lot to be said about what's old as well. But having something new like the CRT is very useful because it can then exert change across the sector as well. So I want to be quite supportive of the CRT work, which I think is fascinating. And of course, Canada is really leading the world, I think, in terms of the CRT. But again, it probably comes back to also a question that popped up on the side by Mina, who was asking about security and confidentiality. And I might just touch on that because it's something, of course, that arises in the context of apps. And I've got to say, as part of another role, I'm the National Broadband Network Industry Dispute Resolution Advisor in Australia, which is the government-related organisation that's rolled out broadband across Australia. And so I deal with disputes between telecommunication companies and NBN, and fortunately there's very few disputes. But it's been really interesting over the last 6 or so years talking to technology companies about security and confidentiality. And I really have to say that if somebody really wants to hack something, they can hack it. And there is no fail-safe system. There are other issues that aren't raised by that question by Mina, because she asked, have the apps been hacked? No, they haven't been so far. Can AI track fraud? Yes, it may be able to do that, but I think you've got to build that into your system. And I think inevitably you'll need a human to be engaged with that. How do you deal with abuse? Well, AI can't deal with that. And in the situation I was giving, I was really talking about, I think, situations where if there is abuse, it's not abuse which is considered to be so problematic that it will prevent parties, if you like, from reaching a settlement. But this issue around data security is a really, I think, a key issue. And anything can be hacked. You can extract data. What worries me more, though, is that I looked at some research in relation to mental health apps, and unbeknownst to many of the app developers, there was actually an on-selling of data to third parties in relation to mental health apps. And that's a real danger in the justice area as well, that we may use platforms to develop great justice apps, but in fact those apps are unbeknownst, because it's very hidden in the privacy agreements, unbeknownst to us, on selling data which might be used for retail and other purposes, who knows. So I think there are issues, and it's certainly one of the criteria that I've developed to evaluate apps, is really considering confidentiality, privacy, data security. All of these matters are, I think, relevant for the future. But maybe we're all changing the way that we think about this as well. I know that I sign up to apps sometimes now, whether it's Uber or it's something else, where there's a lot of my data that I'm sharing. So this is a really interesting question around, have we changed our views about privacy?
Yeah, but actually that leads me to my next question. It's a more theoretical, open question. So the title of this discussion is Reimagining Justice with AI Tools. Do you think that we should rethink entirely the justice system with the idea that technology could reshape it? Or do you think that AI technology is just another tool that can just be added to the legal actors toolbox?
This is such a good question. I got quite excited when you just gave that question, because I think that there are two very different views around technology and justice. And the first thing I probably should say too is that often justice is just equated with courts and judges, and I see the justice system as a far broader system, which includes in Australia what is a vast complaint handling system. It includes the ADR systems, it includes the way in which people access legal advice. However, sort of looking at courts and judges for a moment, there are two different approaches that have emerged. And on the one hand, we have Richard Susskind in the UK, who describes himself as a radical, and really, I think, it suggests an approach where there is a complete reform, a three-tier reform system of the courts, where Tier 1 and Tier 2 are managed by the executive. Tier 3 is reserved for judicial adjudication, with human judges initially, but being replaced at some point by forms of AI. Now, Professor Susskind regards himself as a radical and says that freely in his work, that he takes a radical view. And that view is driving some reforms, I think, in the UK, although I think things have slowed down a little in terms of those reforms. So we have that more radical view on the one hand. And on the other hand, we have a much more incrementalist view. And the incrementalists, and that's how Susskind describes them, I think have emerged more in the US. So in the US, we see IELTS, which is a major organisation in the US, coming up with 27 different ways in which technology could be integrated, if you like, bolted onto existing court systems. And they've really talked about it in the context of more outwardly focused case management reform, where you have a slow build on and you build different tools to if you like, reform what the court system looks like. So these are very, very different approaches. And again, in China, I would probably say that the smart court system reforms are in the more radical pile, and that you've got a system of 5-year reforms often that are really extensive, have led to complete digitisation, and have led to the creation of a virtual court system, and indeed an AI system that's emerged as well. So which way are we likely to go into the future? It all depends, I think, on your jurisdiction. And I do have a concern that sometimes we might just pluck something from one jurisdiction and think that it works in our own. However, really, in terms of any system reform, the first thing you need to do is an environmental scan and actually work out, well, what works well and what are we already doing well? And, how can we build on that, and what's required? Do we need to do something quite different, or can we add on as the IELTS approach? And that response is going to be different for every country. And It's going to be different because some courts are really already very well digitized, others are not. Some courts are already able to do most things virtually, others are not. And some have begun to experiment with AI systems and others have not, and don't consider that they perhaps ever should, although they may not have considered supportive judge AI. So I think in some places we're going to get more of that supportive judge AI development than anything where judges are actually replaced. So it's a great question because it's really a bit of a wishy-washy answer to say it's going to depend on your jurisdiction. But this is not an international reform measure that's taking place. Court systems are individual, they're idiosyncratic. And really, if you examine the responses to COVID-19, it's very apparent that the responses are quite idiosyncratic across the globe. As to where I probably fit, I'm probably in the middle between a radical and an incrementalist. I can certainly see a lot of benefits with incremental approaches. Sometimes that's a better way of educating people and changing culture. And sometimes too, it's a way, I think, of experimenting and piloting so that you're not investing a lot of money in something which might not actually work or which might change in 5 or 10 years' time anyway. And with technology, that's a real risk in that we will see again and again developments being leapfrogged over as a result of the tech changes over the next decade. So it's a really tough question. Thank you for asking it.
It was an open question. I knew that question also would be hard to answer. I have a question from Clea. She missed the name of the US example you just gave.
Oh, sorry, that was IALS. The IAALS. And their work is really interesting. So IALS has also been doing a lot of work on regulatory sandboxes as well, and very interesting work. And they're of course out of Denver in Colorado. And I think what is interesting, it's about the advancement of the American legal system. But what is really interesting about their work is that they have a lot of judges who've been engaged, I think, in that approach. And the 27 areas of reform, I think it's 27 in the case management area, are really interesting because they completely shift a case management system from something which is more inwardly focused to something which is outwardly focused. So IALS, I'll type it in the chat box so that you can see what it is.
Mina is asking if we can trust the quality of justice data from China.
Well, China is still fairly closed. I mean, it's been difficult. I've been working with 2 Chinese scholars on some of the work on the smart court system. And this is really one of the issues around the independence of the judiciary as well, in that if you have a system, for example, a criminal system that is used to charge people, and in essence, you're using a similar system in the courts, then odds are you're going to have most people being convicted because it's almost the same system. And then there are other issues in China as well, which are related to the social credit system, which I think many in the Western world are concerned about because, you know, this is the linkage of different pockets of data to give you a social credit score, which then impacts on your capacity to buy consumer goods or travel or send your children to a good school or whatever the decision is. And many people don't actually understand that that social credit system is in part curated by the justice system in China, by the courts. And in China, I think this is regarded as being a great system because people who don't pay their debts or their fines or whatever can then have a lower social credit score, so they're punished for not doing things. But I think elsewhere in the world there's a real concern around whether or not, if you express political views or you have some other concerns, that your social credit score might be reduced. And then there's a question which is linked into the independence of the judiciary. So the quality of justice data that comes out of China varies. China is a vast country, but it's been really great to be looking at the development of the smart court system, because when they first started their reforms, so if you look at a lot of the Western country reforms, we were really doing a lot of case management reforms in the 1990s and even in the 1980s. And that was because it was really predicted that there were so much litigation that the courts wouldn't be able to handle the amount of litigation that emerged. And so there were lots of case management reforms done in the 1990s across the world, whether you were talking about Lord Wolfe in the UK or whether you were talking about Australia or whether you were talking about Canada, all of it really driven by an access to justice agenda. At the same time in China, their justice system was only beginning to really grow in response to increased economic activity. And their real boost in economic activity, a lot of it happened in the 2000s and beyond. So they have had access to different technology and technology that we really didn't think about in the context of our case management reforms. When I say our, I mean a lot of Western country case management reforms. So their smart court systems have really been designed on a very different platform. And they've been designed to deal with what are now millions of cases. And it boggles the mind when one thinks about how you can deal with millions of cases. And their response has been to use technology to deal with these millions of cases. And so their systems are really, again, quite different from the systems and approaches that have been used elsewhere. And I think the data that is coming from these systems is fascinating to explore, and I think really interesting in terms of what it might mean for the rest of the world. But it explains, I think, very much too why there has been this huge uptake in technology in China. The timing of their surge of cases was very different to what happened elsewhere in the world. And the timing coincided with, I think, a lot of technological reforms elsewhere.
Okay, so she commented, the problem with China is that it has technology, but no individual rights. So it's a comment. That's not a question. Coming back to the pandemic, we talked about very little, but with the pandemic, there is a sense of rushing towards this technological shift in the justice system, for example, in Canada. Do you think that the pandemic would have or already have a positive effect on the modernization of the justice system?
Yeah, again, I've written the impacts of COVID-19 on justice systems around the world, and the impacts have varied. In many places, though, you've seen really an abandonment of jury trials, or you've seen a pullback in relation to some justice activities, and then a huge increase, of course, in online hearings and online court events, interlocutory and other events. It is having an impact. It will have a lasting impact. Again, there needs to be some more evaluation research in terms of what it actually means. And the research out of the UK has been probably the best so far that I've seen. And that's been interesting because it really shows that for some vulnerable people, they either haven't been using the court system as a result of the pandemic and the switch to an online system, or if they have been using it, then they've had technical and other difficulties that have really prevented them from engaging adequately. So on the one hand, you've got some people who've thought, yes, this is great. This is really working for me. But then there is a pool of vulnerable people who are affected adversely by the switch to more virtual hearings and the use of technology. And every jurisdiction, I think, needs to consider and evaluate what's actually happened in the COVID era to be able to make some clear-eyed decisions about how to move forward. There will be more retained. I think the shift towards the digitisation of all court records will be retained. There are some shifts that are a bit of a concern, perhaps, and so there is another shift to really deal with matters on the papers if you're using forms of AI, and that can be appropriate sometimes, but it might not be appropriate in other times. And then there are even some other shifts around whether or not judges should change the way in which they craft decisions that they make so that they're more machine readable. These things are happening in the background of the pandemic, not because of the pandemic, but in a sense, the pandemic has forced us into a situation where we have to consider innovation more seriously. So we've accelerated our our change, the question of the lasting impacts is a good one. There will definitely be some, whether they're as extensive as we thought that they might be is a question also around supports offered to vulnerable litigants. I did see that in the US, and certainly in some other countries as well, there's been a focus on how more vulnerable litigants can be supported through the use of, justice kiosks and facilities where they can go and be better supported when they need to complete material or engage. And I wrote an article recently on death sentencing via Zoom. And really the question I was asking is, are there circumstances where it is never appropriate to use Zoom? And what are those circumstances? And where do we draw the line? And what happens when a person receives a terrible outcome via Zoom and they're not supported in terms of that outcome? So these are, I think, interesting questions.
I have a question from Ms. Fraser. How do you see AI contributing to the growth of ORB, where decision on there is a problem in the typing, I think. So how do you see, it's in a question, a QA box, online arbitration, okay, where decisions are final and binding, i.e. what type of support do you envision AI being able to deliver?
Okay. So how do I see AI contributing? Sorry, I've just pulled it up. It's on a different box. In terms of AI contributing to the growth, I do have concerns about final and binding. I think initially we need to keep, there's an expression about humans being on the loop and humans being in the loop, which really applies to the extent to which humans are involved in the initial AI design and the extent to which there is human review of the decision making. Initially, what we're likely to see is more supportive forms of AI where you still have a human decision maker and the form of AI produces, if you like, a template decision that is then checked over by a human decision maker. There are issues with that because it's likely that anchoring bias and other impacts will mean that, and also the sheer busyness of work and the work plans that are in place may mean that the human decision maker doesn't really properly review what's being put forward. So I think we will see a growth in that area. And in terms of final and binding decision making, I suppose the AI initially can be advisory and let parties know what the likely range of outcomes is going to be in terms of the arbitral decision, and then it's up to them about whether or not they proceed or they want to progress. In a sense, that might give people a chance to strap up their cases before they take it on to the online arbitration. And I think that there is a concern there that the more well-resourced in terms of AI understandings, the more well-resourced litigant may be advantaged, which is a concern that I've got. So I don't know whether I've really adequately answered that. From my perspective, there are always some appeals from arbitration in my own jurisdiction, unless it's in relation to international commercial matters where there are very little opportunities for appeal. But in international commercial arbitration, I'm not necessarily seeing AI as being as important initially because they tend to be quite idiosyncratic and complex and can involve multiple parties. So I don't know whether I've adequately responded to your question. And it may be that this is really a jurisdictional question. I would have thought that you need to have some review mechanism where you've got a form of AI that is actually making the decision making. On the whole, it's more likely to be a human review process, at least initially. But beyond that, there may be another form of review that has to be developed. So hopefully that deals with it.
There is another question. Can you recommend ways to keep up with the advancement in AI and law and access to justice?
Oh boy, that's a tough one. I spent a lot of the COVID period. We didn't really lock down that much in Australia, and we remain not locked down. But a lot of it is spent reading and reviewing. And there is such a vast amount of literature that is now emerging in this area, and it's different in every country. And I think what's been positive about the COVID era is certainly that there are so many international webinars that are taking place on a regular basis, which can highlight some of those areas. The hardest part, I think, is that it's the developments in each jurisdiction are so different, and the review reports are so different. And so I would probably say that what you need to do is keep an eye on what goes on in your own jurisdiction, engage in webinars that are happening, I think, around the world. And the great thing about COVID is you can attend a webinar in the UK, or you can attend one in Australia or in China or in Singapore. And these are really interesting ways to find out what's going on, because often as an academic, you write a paper, and of course, then it's about 6 months later that, it goes through the peer review process and eventually gets published. And really in this area, you can be out of date so quickly, it's problematic. And so academic papers, yes, very useful. I probably would recommend some websites if you're interested in academic work, definitely Social Science Research Network, SSRN. You can download free material, and often they're the papers that academics put up when they've sent them through for publication. So before they've had a peer review, they're often good sources. But it's a difficult task to keep up to date. I think if you're looking at COVID response, the Remote Courts website is quite good. But really there are, as I said, developments happening across the place. And I tend to loop in through Twitter and LinkedIn, and people just send me stuff, which is really useful. But to actually do this research is a huge job for me. And I've got to say, it was an enormous task to complete the book, Judges, AI and Technology, which I'll have out next year. It was, a very extensive literature review effort that really requires updating almost on a weekly or fortnightly basis. Yeah.
Okay. Is there a risk of AI embedding and entrenching certain biases, with stakeholders not realizing these biases until much later?
There's a quick answer to that, and that is yes. Of course, there are already biases across the justice system, and part of the issue is that those biases will be replicated. And yes, that's definitely, I think, a live issue, which is why the human on the loop and human in the loop processes really need to exist. But I agree.
It's one of the questions about AI. Anyways, it's going to be interesting to see if we can overcome that challenge of biases. I have a question. What is your opinion about predictive justice?
Predictive justice?
Yes, the apps that advise citizens on probable results of a legal process.
I think that they can be quite useful if they're correct, and if in fact the data set that's been used is adequate. The big issue with a lot of these is that I think sometimes people consider that you can just look at, for example, court file data to be able to skim that court file data and get a view about what the likely outcome would be if you progress to a hearing. However, other research that I've done, I had a web crawler invented a couple of years ago to look at all of the case files in our Supreme Court in Victoria and our Supreme Court in New South Wales, and only, of course, a very small percentage of matters ever progress to a final judicial determination. And I looked at that, 1.5% to 3% of cases that progress through, and they had a lot of aberrant characteristics in that there's a reason why they progress through to a court hearing, and the reason why they progress through to a court hearing is often because they're complex, and often also because there are behavioural abnormalities. And it was actually quite surprising because we did a search on whether or not death had been mentioned in the background of a case, that's death of a litigant, or there was death at least appearing in the context of the judgment. And in about 30% of cases that appeared. And I wondered whether the cases that progressed through to a final hearing, they were so unusual because there might have been a grief reaction or some response that was driving the litigation in the background. In any event, my point is that cases that progress through to final judicial determination tend to be aberrant for one reason or another. And if you only use that data, then you're actually going to get some unusual responses because the cases are unusual. And so we need to use a really big pool of data. And so my response is that yes, predictive AI, where you're able to give an idea about what the range of potential outcomes is that a court can come up. These tools can be very useful. They're not the only tool though, and it is wrong of us to consider that a litigant, if they're just told what the response is going to be, will necessarily settle, because in my experience, in my past research, that's not the case. They need something more often. And in terms of how that predictive AI is developed, there are real issues if the data sources aren't adequate.
Okay, I have another question. If lawyers are leery of AI as it applies to law and potentially recommending it to clients as a solution, what would you say to them in order to encourage them to make that leap of faith?
Another good question. I was really interested in the results of that evaluation that I did with a Jew looking at that particular app, because the lawyers involved that I had interviewed were concerned about AI, and their clients were too. But that form of AI, which was really just looking at a subset, if you like, of the client's issues relating to what their financial circumstances were and who had made contributions, it saved so much time and money that clients and lawyers supported it. And I think it needs to start small when we're looking at how clients and lawyers consider forms of AI. And it needs to be, well, is this actually helpful to the client? And I think give feedback to app developers as well and others to say, this could be more helpful if it did A, B, and C. In terms of the actual apps themselves, or in terms of whatever you're using with your AI, it needs to be friendly, and it needs to be better than a lot of the apps that exist on your phone at the moment. It needs to be simple, and then clients will use it. So I think for lawyers and clients, it being low cost, it being simple, it being translatable, and it being useful, all of these are important questions. But lawyers are shifting, and I know my own law students here at Newcastle in Australia, we do a fair bit of work with apps, and law students are interested, and they genuinely, I think, are interested in results for the clients that work. And if something works for the client and it works for the lawyer, then they will use it.
Another question from Mina, referencing the movie Minority Report. In the movie, the prediction was wrong. Have you seen the film, and do its themes also apply to AI?
I haven't seen the film, I'm sorry. But it wouldn't surprise me that a prediction was wrong. In my my book, Judges, AI and Technology, I talk quite a lot about the wrong prediction and the dangers that we have about AI accuracy. And this is a risk, but there is also a risk with human accuracy as well. And humans make mistakes, as we know, through the many innocence projects that exist around the world, where people are found guilty and then years later are found innocent. Again, it's no complete excuse, but I think it's something to bear in mind. Now, I think we must be coming towards the end of our session. Is that correct?
I think yes. We don't have other questions, so I want to thank you. It was very interesting. I'll learn a bit more, and I hope we can do that again. I mean, it was very interesting, and I hope you enjoyed this talk too.
I did. I really enjoyed it, and I want to thank your audience as well for the excellent questions, which really woke me up this morning. It's now 9:15 here in Australia, so I thank you for waking me up with your interesting questions. I greatly enjoyed the conversation, and thank you for bringing me onto the webinar and also running the webinar.